Please be seated. Good afternoon, Counsel.
Good afternoon, Judge. And the state intends to ask the court to continue the preliminary hearing scheduled for today at least 2 weeks out. And I'll put the reasons on the record, but that's our intention today. We need written verification from the defendant in that case about surrendering his law enforcement license. A couple letters need to be sent out both to my office and to CPOST. Once we have verification of those things, we'll end up dismissing the case. So we'd ask that preliminary hearing in 13 CR 45 be continued out a couple of weeks, and maybe actually even setting that for a telephone conference with the court.
And let's see, Mr. Brown.
I see Chris Brown on behalf of Mr.
Yes, you're his attorney.
Yes, sir.
And that's what your understanding is what you gentlemen are going to try to resolve this case in that fashion.
That's correct, Your Honor.
Okay, well, if that's the case, I don't have any problem with going ahead and delaying disposition of the case so that these matters can be taken care of. All right, Mr. Curry, let me go over a few things with you and make sure that you do understand what you are doing here today, and that you understand what you're giving up and what this diversion means. Did you in fact sign this document?
Yes, Your Honor.
All right, and did you have time to go over this document carefully with your attorney before you did sign it?
Yes, Your Honor.
I imagine that we have both attorneys from the media here.
We have responses to the motions to unseal from both the state and the defendant. I'd like to emphasize, though, that even though this is styled as a civil case, it's not the kind of civil case that we typically encounter. This is an official state action against a law enforcement officer, the chief law enforcement officer of this county.
The people of Franklin County still want to know why a civil petition in ouster was filed. And further, since there is a diversion process, they want to know and decide for themselves whether that was an appropriate avenue for the resolution of this matter. And they can't do that based on the information that they have now, or more specifically, the lack thereof.
The reason we close those by statute is they often contain information from confidential informants, from other unindicted co-conspirators, other defendants, other witnesses. We seal that as a matter of law so the court has a chance to look at that and make a reasoned decision about whether to unseal it or not. I don't know why Mr. Miriam thinks the criminal case has been sealed. That's ridiculous. There's no order sealing the record. The clerk's office is open. You can go in and get whatever you want. You just can't get the charging affidavit.
There are allegations made against a third person by a confidential informant that are untrue. And law enforcement has confirmed that that confidential informant, that those allegations were subsequently verified to be untrue. At the very least, if the court is inclined to unseal the petition for ouster, I would urge the court to, at the very least, redact the identity of the parties that Mr. Hyatt alluded to for law enforcement purposes, but also for the privacy concerns that I've addressed in my motion.
It's this court's opinion that closure and sealing should only be used in the most of extreme and compelling circumstances. And the court finds in this case, especially after what has occurred here today, that there just simply are not any factual circumstances that are compelling and that would outweigh the public's right to know. Any previously existing necessity for ouster or for sealing the records, in my opinion, has been removed. Therefore, the records pertaining to the ouster, all of the records in the ouster proceeding, shall be unsealed and shall remain open for public examination by the media or any person in the public that might be interested in the matter.
I wasn't certain
how to intervene and remain anonymous. But I represent the third party, and I would ask the court to consider a redaction of the third party's name from the ouster petition, allow the petition to be unsealed, which will let the county know what happened in this case and why, without prejudicing my client's right to a fair trial in the event the investigation, which is ongoing.
But just for purposes of so that this matter could be open right now and to protect the clerk's office, I've just made just a short handwritten order that says on this first day of April 2013, it's by the court ordered that all pleadings in this case are hereby unsealed and are made available to the public and the media forthwith, and then I signed off on it. Okay, counsel, is there anything else that we need to take up?
Nothing from the state, Your Honor.
Nothing from the defense.
Okay, very good.